developments, even as the referendum plans have been jolted in one way or the other due to the strict timelines. Still with our panelists in studio, Professor Gitile Naituli, I'd like your take. We just heard from Dr. Matsanga. He's not bothered with the strict timelines as it is. The reggae tune will still go on. What's your take on this with the court date set?
I think the timeline should bother my colleague, Dr. Matsanga, because the court will hear this case basically towards the end of this month in July. You have to know that the election is scheduled for August 9th, 2022. Just to be specific, August 9, 2022. The referendum should be held, in my opinion, by August 8, 2021. Okay? Now, that is unlikely to happen because this judgment may very well come either at the end of July or the beginning of August. And then let's say now whoever loses go to the Court of Appeal, to the Supreme Court. That will take another 2 months. So we are already into the period, the electioneering period. So it's tricky. I don't know how this thing can be done. That's why I will support that IPPNG method of picking what was good and valuable in the BBI, which was good for the country, which can go through Parliament without inviting our participation as public participation. That was, in my opinion, I don't know why it has been opposed, but it's a very good idea to salvage what is really good in the document. Because for a referendum to be on before the election, I think that is a bit challenging if you look at the facts.
Okay.
I didn't say it's impossible. I said it's challenging. I'm very careful the choice of my words.
Okay. We'll hold you to account, Professor. So, Bashir, what do you envision here in terms of the initiative proponents arguing it out in court? There might be a possibility of a Supreme Court option as well. What's your take on the timelines?
Just let me say this. When you look at what a referendum is about, a basic definition of the word referendum is subjecting questions, giving an opportunity to the electorate to vote on questions. Let me give you an example. In the UK, since 1973 to date, it has undertaken 11 referendums. And the UK has no written constitution. The UK constitution is an unwritten constitution. So imagine a country that has no written constitution, that may not have something documented on how it shall be undertaken. Between 1973 and now, it has undertaken 11 referendums. Okay. This is a right that is provided for under our constitution. Any promoter of an idea who may want to amend the constitution, he should have it in a way that he can attain his or her own objective upon subjecting it to the people of Kenya. I think the proponents of the BBI have gone that trajectory. They have tried to amend the constitution. Where are we finding ourselves at the moment? The other day we had that pre-trial conference, the case management at the Court of Appeal. The case management was a very important stage whereby the parties were to agree on the timelines, the procedure of submitting to the court, any objections or any issues that are of urgent nature that the court should address, how to exchange the submissions, the timelines and the pleadings and all that. That has been agreed upon. The court has said, for instance, that within 4 days it shall be able to dispose of the hearing of that. That will end on the 2nd of July. So let's say, just for example's sake, that the judges, let's say they need like 30 days to about 3 weeks, let's just say a month, that they will need to maybe come up with a judgment on that. Going forward, let's say any of the parties again appeals to the Supreme Court without, and I'm a bit cautious, I do not want to sound the prophet of doom on this. I still envisage, or I still insist on how to make it easy for any single Kenyan to propose to amend the constitution. Let him be given that time. But the practicalities that we're having ourselves are certain challenges that a promoter, because this issue has spilled its way in court, assuming that again any other party appeals to the Supreme Court and what have you, and again the Supreme Court decides, that will definitely see us towards the end of this year. Just now, when we come to the next year, that will be an electioneering period. Noting that a term limit of the 5-year term will be ending on the 2nd Tuesday of August, 5 years, which will be about 2022 August. Yeah. Just now, the next thing is, how does a referendum take place? the IEBC will need about 90 days to maybe consider the verification of the voters, update its register, disclose it to the members of the public, and what have you. And that is the time that we are equally be faced with a general election. Not unless something is done with respect to the conclusion of the case before the Court of Appeal, and maybe, for example's sake, in the event it finds its way at the Supreme Court. If that can be done, which is practically challenging by September, in the event this spills over to January 2022, we will find ourselves in a different conversation whereby certain castigators will start arguing that, hey, let us do the referendum together with the general election. That is the argument that we are going to see.
Okay.
But Jesse, let the referendum be easy for all people. The UK, with no written constitution, has done or has undertaken 11 referendums between 1973 and now. It is an opportunity for any promoter of an idea. You might need to amend the constitution tomorrow, or myself, or any other member of the public.
Just let me quickly give you some roadblocks which I see. You see, by February, according to the Election Act, the parties must begin to submit their party list, so that by April they are submitting the nominations.
Yes.
So all those timelines, they make it imperative that they are done without other side issues. So I don't know. I think eventually we will calm down and they see that we need the change as proposed in the BMBI, and that we can do it in a more, not in a Russian environment, but in a calm environment.
So it might land after the election or the IPPG approach.
Yeah.
Bashir, Kagoni, before I go to Kagoni, he mentioned something about conflict of interest. The courts using IEBC to actually get the appellate president, but yet they indicted IEBC not being properly constituted. How do you look at this?
You see, Jesse.
But let's say correct Kagoni there.
Okay.
The court has never, there is no judgment or ruling of the court that has said IEBC is not properly constituted. What the court is saying is when IEBC makes a policy decision, then it must have a quorum of 5 according to IEBC Act. I think we need to be very clear on what we are saying here. We need to go to the facts.
Okay, Bashir.
I think, Jesse, contrary to what Kagoni thinks, let me even try to convince him this way, that our courts, the decision or the kind of position, the new position it has taken on the quorum question of the IEBC is quite practical. The court said, look, let us subject the other issues, the declaratory questions to the Court of Appeal, but on the question of quorum, let us stay the declaration of the High Court. The courts are very practical. The courts are trying to allow IEBC to proceed with its by-elections or with other processes. This is what we need to appreciate about the court. The courts are supposed to, or they are allowed, there's a provision in law that allows the court to reconsider certain issues, to stay them, as we discuss the other issues together with that within the Court of Appeal. So I think, contrary to what the others think, the courts have been very practical to allow the IEBC, in as much as we are having the quorum question, to proceed with its processes. Just to throw in a very first opinion on that.
Yeah.
The IEBC Act, when we look at it, vis-a-vis the Constitution, there are certain conflicting provisions. According to the IEBC Act, the quorum is supposed to be 5. Whilst our Constitution provides that constitutional commissions shall have a minimum of 3 members. You see, Jesse, this is an issue of law. It has found its way at the Court of Appeal, but my opinion as a lawyer is this. I appreciate the position the court has taken on staying the execution of that declaration so as to allow the IEBC proceed with its provision, even as we await the outcome of this.
Wakili, I don't see any conflict there, because the Constitution says a minimum of 3, maximum of 9. But the Constitution also just below there says that Parliament will make law to provide for operations of that boundary. And in that provision, Parliament decided the quorum was 5.
Jesse, I will just say this. If you invite me here next time, I will need about 30 minutes to explain to Kenyans broadly why this is the case. But for now, let me just say this. This is a court matter. Okay. Let us away how the position of the Court of Appeal on this.
Yeah, let's not go into the board of sub judice. But anyway, Kagoni, talk to us about the timelines at the IPPG option, which has been fronted among some members of parliament. What's your take on this?
I actually want to agree with the prof on that, because when you look at the proposals that are there in the BBI, you realize that around 45 to 50% of the proposals are administrative, and others can actually be passed or amended via Parliament. And now with the new handles that are coming, the court cases, the timelines and all that, I actually want to agree with him that maybe there are things that we can be proceeding on from a Parliament angle and amend them. For instance, and I want to give you an example of this, we can deal with the CDF Act now. We do not have to wait for the BBI to pass to actually take care of the proposals that were there. We can just proceed with that. There are quite a number, when you take on some of the proposals that are there, there are things that we can work on from a Parliament angle, and others are purely administrative. We can be dealing with those ones. Just in case there will be eventualities where the timelines might be affected real big, and that would actually be an issue. The other angle, and I want to, I think is Suleiman was mentioning this, and I want to agree with him, is that when you check now and we are nearing the elections, you wonder what timelines, how do you really separate these two? At what point now the IBC will have time to prepare for the general elections? At the same time, they are supposed actually to carry out a national a referendum, which is also purely something quite huge. I find like the time that we are not very, I wouldn't say that the zone is very comfortable and the timelines are very favorable, so to speak. That might be something that the promoters of the BBI might need to be alive to and see what could be actually the alternative. And if the alternative is maybe to have a combination of the two, the general election and the referendum, fair and good. But at the moment, what we could seize as an opportunity is to see what are proposals that can be dealt with administratively and through Parliament.
Okay.
Yes, sir.
Yes.
Yes, sir. I can come in here and separate Bashir from Professor. At this time, I think I buy a bit of Bashir's idea. But look at this. The Parliament of the Republic of Kenya can extend its lifetime. Yes. Don't narrow yourselves on doing a referendum on the same day of the election. There is a pandemic. We don't know when, how, which date we shall finish. It could become worse in July, tomorrow, December, next year. Looking at all those circumstances, the Parliament of Kenya could sit down and say, excuse me, with all these things, we want a free and a fair election. And that free and fair election, without reforms, if the reforms are not there, there can't be a free and a fair election. Point number two, whether you go to India Gabriel and then come back to Nigeria's coronation down here, and then go back, the people are sovereign.
All right.
The only, let me finish it. Yes.
Briefly, sir, our time is up.
Yes, the only threshold that can reject, change, alter, can be made through a referendum by the people.
Okay.
You cannot reach halfway and bring what Professor Naitiri and Jimmy Kagoni are talking about.
Okay.
It is the people's threshold. This reggae is going to be danced up to the end.
Exactly.
Whether you Kenyans want to extend your constitution at your parliament, it is up to you. That is my submission.
Wouldn't that need the people's approval as well to extend Parliament's life? That would be the question that needs to be answered. But due to time right now, allow us to end it at that particular point. I know a couple of issues that haven't been touched on, but this is an ongoing conversation. And gentlemen, I'd like to appreciate you for your input. However divergent they have been, we definitely have reached a bigger understanding. The rule of law is the greater winner right here. So it should be followed either way. Suleiman Bashir, many thanks for your legal input. Lawyer advocate, Professor Gitile Naituli as well.